Hello, everybody. My name is Tom Gretsch. I'm the president and CEO of the Queens Chamber of Commerce. Welcome to Chamber members and friends. Happy that you're part of this program being put on by Ron Fatoullah, attorney. The title of it is Don't Put a Roof on Your Business When It's Raining. You're going to learn a lot today about protecting your business. Ron, thanks to you and your team. We look forward to the program.
Hello, everyone, and welcome to the Queens Chamber of Commerce new webinar presented today by elder law and estate planning attorney Ronald Fatoullah and business and litigation attorney Robert Mehran. My name is Jacqueline Donato. I am a strategic program manager of the Queens Chamber of Commerce. We are a membership organization established 111 years ago, and we are working for a better business community in Queens. When our communities are good, businesses are good also. Queens Chamber is pleased to sponsor webinars and in-person events, providing resources to small business owners in Queens. Our outreach business specialist, Julio Vargas, is joining us today, and he will be supporting the Q&A and posting the webinar in our YouTube channel. We will be sharing the presentation in our YouTube channel for future resources. And also I welcome you to share this important presentation with your network. Once again, thank you for being here. I look forward to work with all of you. And Attorney Fatoullah, the floor is all yours. Welcome.
Thank you so much, Jackie. I really do appreciate it. I do have slides. I just want to let everyone know that I'm a Queens boy. I was born in Queens, grew up in Queens. I went to Queens College for a while, and it's just so wonderful to be here today and to be able to talk about this very, very important topic. So I am going to share my screen. I do have slides. Let me get to that. All right, and I hope everyone can hear me, see the slides. So I've called this succession planning for yourself and your family. Rob Mehran, who's a great attorney, and we work closely together on so many matters, is going to go over succession planning for your business, but I'm going to touch upon some of the estate planning, succession planning that you need to do, and personal succession and estate planning that you need to think about. Let me just, okay, here we go. First thing that everyone has to do, and every time I lecture, I talk about it, you gotta get your team together. You don't want to wait till the last minute when something happens and say, oh boy, what am I going to do now? Who should I call? You want to have your professionals in place, which is your attorney, your financial advisor, your CPA. If you have some sort of condition as you age, it might be a geriatric care manager, your doctors, etc. But you need to get your team together for yourself. Number one, and don't wait for the last minute. Okay, now I want to talk about estate and gift taxes. And things are always changing and always shifting. And there's so much to talk about estate planning for yourself, but also for your business. And we're going to get to that in a couple of minutes. But right now, there's a unified credit. We call it an exemption, the exclusion. The gift and estate tax exclusion right now for 2022 is $12,060,000. It's scheduled to go up in 2023. We already know the number. It's almost $13 million, 12.92 million. But you need to know that it's scheduled under current law. Nothing has to happen, and this is what's going to happen if nothing else happens, if the law does not change. On January 1, 2026, a couple of years from now, this number will be halved. So you got to be very careful. I speak to a lot of people who say, oh, I don't have to do any estate planning or gift tax planning because I'm fine. You know, 12 going up to almost $13 million. I'm fine. Well, it's going to be halved under the current law. So you need to know about that. So what does this mean? We have this huge unified gift tax exclusion. Let's call it 12 million. What this means is that if you make gifts over and above an annual exclusion amount, which currently is 16,000, going up $1,000 next year to 17,000. That's the last bullet point on this page. So any gifts that you make above 16,000 this year and 17,000 next year is taxable, but then you have this huge exclusion. So for federal purposes, you're not going to be taxed by making gifts, let's say to the next generation, to your children, grandchildren, siblings. You're not going to be taxed until your gifts exceed that exclusion amount, which is huge now. Again, 12,060,000. And when you, and for next year, it's 12,920,000. Huge. So what the government wants you to do when you make gifts over that annual amount, currently 16,000, is to file a gift tax return. It's a Form 709 to let the government know that you've made a taxable gift, but you don't have to pay any gift taxes because you have this exclusion, but you're eating into that exclusion. So step back and let's think about it. The government wants to tax you on whatever they can. If you make a living, they want to tax you on the income that you make, your income tax. If you have a capital gains and you sell your home, or you sell a building, or you sell a stock, there's a capital gains tax. You take out a mortgage, there's a mortgage tax. Well, this is the ability to get money to the next generation. And this is a unified exclusion. It covers a gift and estate tax. So if you make some gifts that are taxable, where you eat into your exclusion and you reduce it, then you're going to have less of an exclusion when you pass away and you give money, for example, to your children. So let me give you an example. I like Rob so much. If I'm going to give Rob $16,000 now, what do I have to do? The answer is zero. It's an annual exclusion gift. I don't pay any taxes. The receiver of the gift doesn't pay any taxes. If Bill Gates was going to give Rob $1 billion, how much tax does Rob have to pay? I see his face, see his smile. It's a nice dream. Just like the Powerball lottery, which is like 1.2 trillion. I don't know what it is. It's $1 billion, some crazy number. But if Bill Gates would give Rob you $1 billion, you just say thank you. The receiver of the gift doesn't have to pay any tax. It's the giver of the gift. Bill Gates will have to pay a gift tax. So it's always the giver of the gift for the ability and the privilege to give the money that you work so hard for, that you probably paid income taxes on, now when you make gifts. But that's why they give you this huge exclusion. But remember, it's going to be halved in 2026. But let me go back to my example. I give Rob $16,000. He says, thank you. I don't pay any taxes. It's an annual exclusion gift. I could do that to any individual in a taxable year. I could give Rob December 31, $16,000, January 1, $17,000. It's going up $1,000. I don't have to file anything. I don't have to pay anything. I don't have to do anything. And Rob doesn't either. It's a pure gift. But if today I give Rob $116,000, first $16,000 is free. The remaining 100 will reduce my 12,060,000 exclusion. And that's how it works. So if I give Rob $1 million, that's taxable, $1 million, 16,000, then I'm going to reduce my 12 million to 11 million. And I'll have less later on, but know again that in a couple of years, these numbers are all going to be halved. Now you have to know this is so important. The federal tax rate and gift tax rate is 40%. New York State does not have a gift tax, but it has a 3-year rule. If you make gifts within 3 years of death, they're going to claw it back and say it's part of your estate, and you have to pay estate taxes on that. Currently, New York State's estate tax exclusion is 6.11 million. It's about where the federal level will be in a couple of years. Now, you have to be very careful, because with the federal law, you only pay taxes on gifts once you use up your exclusion, and you have that huge amount. But over and above that level, you're going to have to pay taxes. New York State is very sneaky. And I went up to Albany trying to argue that this was a mistake, a Scrivener's error in the law. And what do we get from the governor's office? This is a few years ago. This is what we wanted. And I'm talking about the infamous cliff. What is the cliff? The cliff says that if you go over that exclusion for New York State, that 6.11 million when you die, because don't forget, New York State does not have a gift tax. When you die by a little bit, they're going to tax you from $1. And there's lots of planning with trusts, etc., that we do to get around that, if at all possible. So that's part of the planning that we do as estate attorneys. So you have to be very careful. You know, don't think, oh, who cares about New York State? New York State's estate tax rate can go up to 18%. When you add that to 40%, you know, on a large estate, it's a lot of money. You know, we're talking more than half. So that's a very, very big deal. Okay, now we spoke about the cliff. Let me talk about portability again. And that's the 4th bullet point. I'm going to switch back to the first slide again. Let's say there's a husband and wife, and there's lots of planning around this. You don't get portability, and I'll explain what it is, by doing nothing if a spouse dies. We have to file. We have to do something. We have to be proactive and take action. So if one spouse dies, and let's say his estate was 4 million, and let's say the exemption amount is 12 million, we can file for portability and have the $8 million that wasn't used go to the well spouse. Why is this important? It's important because in a couple of years, these figures are going to be halved. And soon I'm going to talk about what comprises your taxable estate. And I think most of you are going to be very, very surprised. We have portability for federal law. Do we have portability for New York State estate taxes? No. So we have to do the planning around that too. So we have to plan for the federal and New York State. So that's the sort of holistic plan that we have to do. You should know that any gifts or upon death, any monies that go to a spouse will trigger a marital deduction, and there is no tax. So let's say it's an estate of whatever, $10 million, and everything goes to the spouse. Probably not good plan. There's a trust that could help to protect the New York State estate tax, so there will be no tax in this scenario, but I'm just giving an example. $10 million estate, husband dies, everything goes to the spouse. Any federal tax? No. Any New York State tax? No. But what are we going to do? filed for portability so that the $12 million that the husband did not use could be transferred over to the well spouse. So important, again, because these numbers are going to be had. Now, why is it so important? Because what comprises your taxable estate? Anything you can think of, anything. So a lot of people are very surprised that life insurance is part of your taxable estate if you owned it within 3 years of death. Very easy fix, but a lot of people are surprised. So a lot of my younger clients and older clients, but especially younger clients, have bought life insurance, said, whoa, Ron, it's so cheap. I want to protect my family. So I'm getting a $6 million policy. And look what I'm paying nothing. It's a term policy. That's not part of my taxable estate, is it? And you know what? It is. It is. That death benefit will be part of your taxable estate. How can we fix that? Let's say on that term policy, we just simply transfer the ownership of that life insurance to an ILIT, a life insurance trust, an irrevocable life insurance trust, and it's out of your estate, because the level is going to go down to between 6 and 7 million likely in a couple of years, federal and New York State. And your life insurance would use everything up. Let's say you have a business, got to be valued. That's a part of your taxable estate. Look at the third bullet point. And we have to do estate planning for your business. So what comprises your estate? Life insurance. People are very surprised. Your IRAs, your retirement accounts, part of your taxable estate. Your personal possessions. We had a client that we have several clients that have very expensive paintings, part of their taxable estate. You know, can't fool the IRS. You know, you insure these important items that you have. And that's part of your taxable estate. Anything you can think of that's an asset is likely part of your taxable estate. An annuity. A lot of people think annuities are just off the charts, not a part of your taxable estate. Of course they are. It's an asset that you own, part of your taxable estate, but so is your business. So here's some planning that we can do with trust. So let's say you're thinking about succession planning, and Rob's going to talk all about this, but I'm thinking about estate and gift tax planning. So what can you do? Let's say, and Rob and I work together as, we're such a good team. And Rob, I really do appreciate it so much. It's just great having you and I together on the same side of the fence to help so many people. And it's great brain power, the way I look at it. But anyway, you have a business and you come to us and you say, you know what, I'm not ready to hang my hat up, but I want to do estate tax planning. Right now I have a $12 million exclusion, but it's not going to last for long. I want to do planning. So what can we do? But I don't want to hang my hat up. So there are ways to take your business, whether it's a corporation or an LLC, for example, and let's say it's a corporation. You can create voting and non-voting shares if it's a corporation, or interests if it's an LLC, and transfer the non-voting shares to a trust. So you're getting that out, but you control the business. Your business is controlled by you from A to Z. You just transferred the non-voting shares, and they don't have a say in the business, and we can set it up so that they don't have any control. They may have a majority, but they can't transfer their shares. We put restrictions on who they could give their shares to, So you basically control the company, you can get a nice salary, and you can get that business out of your taxable estate. It's such a great way to do business with your business, if that's something that you're thinking about. So you can't just think about, oh, I'm just going to transfer. You want to do the estate tax planning as well. Now, by doing it this way and creating these restrictions, for the next generation, it might be your children, we can actually gift more money out because we're getting so-called discounts. If the business is worth $1 million, we're not gifting $1 million. We might be gifting 650,000 or 600,000 because what we're gifting is our interests that they can't sell. They can't do that. They can't control it. They are restricted. So the value of what we gifted is less, which means we're not using as much of our unified credit. So that's really good. So anyway, estate and gift tax planning is very, very key. Now, how do we do that planning? And how do we do planning for so many other things is through the use of a trust. And I know I only have about another 7 minutes, but I'm going to just really ram through this really quickly. But what is a trust? Many people call my office and say, I want a trust. And this happened yesterday. And my assistant said, well, sure, we'll set up a consultation. Why do you want a trust? And they said, well, I don't know, my friends have one. And they said, it's a good idea. I said, I don't need a consultation. I just want a trust. Every single trust that we do is different. And it's constructed for a certain purpose. So we do need a consultation and go into it and have a true holistic plan. But a trust is an entity that we create with an agreement. So we work hard on creating this trust agreement. And we set forth different individuals that have different jobs. The creator of the trust is called the grantor or the settlor. The trustee, who can also be the creator, is the individual that manages the assets in this entity and distributes those assets in accordance with the terms of the trust. What terms do we have in this trust? Well, everyone is different for a different purpose. And then we have beneficiaries, but the different types of beneficiaries. There could be a beneficiary for life. There could be an income beneficiary. There could be a discretionary beneficiary. So we have the creator who creates the trust, the settlor grantor, the trustee, and the various types of beneficiaries. If you have a living trust, that's a trust that you create and sign right now. Testamentary trust is a trust that you put in your will. So when you do your will, we actually create a trust, this whole trust within your will. And that's called a testamentary trust. That won't be good until later on, after death and after the will is probated. So we have a living trust, a testamentary trust, and in general broad categories, we have revocable and irrevocable living trusts. Obviously, a revocable trust is a trust that you can revoke and amend. An irrevocable trust is a trust that can be revoked and amended, but only with consent of the trustee and the beneficiaries. And we have a really good fix for that and a workaround for 99.9% of our trusts. So even on the irrevocable trusts, you can revoke and amend them with a bit of maneuvering. We have to be creative when we do this. A will is not a trust. A will just sets forth where your assets go when you pass away, assets that are not in a trust and assets that don't have beneficiary designations. This slide goes over the benefits of having a trust over a will. You don't have to probate. Privacy won't be an issue with a trust. The trust expedites the process of distribution. You don't have to go through that whole probate process. It can't totally eliminate a contest, because an individual can contest the trust, but it's much more difficult. And with a trust, you have continuity of management, let's say of a business or anything else, because your trust will set forth all of these rules depending on your situation. So it's really important. I have this slide in here just so that you know this is a holistic situation. When we do planning for a client, and we do a will for a client and a trust for a client, don't think that you could just download a power of attorney. You know, all of these documents work together. That would be the biggest mistake. So, for example, we have provisions in our power of attorney to make sure that we can work with the trust that we have. So we put this in our powers of attorney, a power to create a trust. Sometimes you need a trust if you become incapacitated, and you won't be stuck later on. That's part of your succession planning. Because if you have a great succession plan and something happens to you and you need a little tweak, you're dead without this. And then we have to go to court for a guardianship action, and it could get a bit messy. Maybe you want to modify something because the law changed in a trust. Well, there has to be a provision in a trust to let you do that. What about the right to exercise the power of appointment that we put in almost all our trusts? What is that? The power to change who the beneficiaries are at any point in time, even if it's an irrevocable trust, etc. And the right to do Medicaid planning. So these slides just go over the advantages of various types of trusts, revocable and irrevocable. There's something known as a grantor trust status. It enables the creator of the trust to pay taxes on the income generated, even though that income doesn't go back to the grantor. So it's a way of reducing the grantor's estate, you know, as a part of a technique to try to eliminate estate taxes. Got to, again, be creative. And here's some slides on that. For many individuals, we want to preserve your assets for long-term care, and we have a Medicaid asset protection trust. That's the gold standard. You could get the basis step up on your house and keep your capital gains tax exclusion. If a home is sold in that trust, it avoids probate. It does all of these great things. And that's another very good use of the trust to protect your home and all other assets. I spoke about the irrevocable life insurance trust, so key and so important. And, you know, when you do a trust or even a will, if you want to give assets to a child on the date that they become of age in New York State, it's 18, so they could go out and buy that hot red Corvette, like Prince said. I don't think so. You know, so we would want to put a minor's trust in our wills. Let's say you have a child you want to give to, and you say if a child passes away before you do, then the assets go to your grandchildren, the children of that child. Put in a minor's trust. It's really important. If you have a disabled child, you want to have a trust so they could stay on Medicaid and stay on SSI and have this war chest so they can do whatever they need, go to a special camp, etc. We have this all the time, and we do these all the time for a disabled child or a disabled individual. We hear this a lot. If there's a spendthrift child, you have a child that's not good with money, you love that child, you want to give to them, but if you give to them, they can't hold on to their money. It's a spendthrift trust. This is all part of your succession, your estate plan, because you want to move to the next level. You don't want to think about what's going to happen to your kids, what's going to happen to you. You just want to get this all together. And there are ways to do that in the trust. If you're concerned about the trustee that you've chosen, we can actually put into trust. Most attorneys don't do this, but it's something we use quite often. You can put in a trust protector, somebody else to look over what that trustee is doing and to give you greater comfort. So we do that quite a bit. So that's my presentation. My time is up. I'm available for any questions that anyone has. And you're going to hear a great presentation from Rob Mehran. So thank you guys so much.
Thank you, Ron. I appreciate your kind words and your friendship. And I also appreciate the $1 billion you got me from Bill Gates and the $16,000. You can sell me the 16,000. Yeah, that's okay.
No, the deal is we got to split it.
No problem. I'm easy. I'm also a Queens guy, born and raised in Queens. I went to St. Francis Prep High School. I remember Bay Terrace when it was just Dante's and El Prado and the white brick building behind that. Now it's quite the shopping center. I want to thank everybody for taking time out of the busy days, and thank you for having us. Ron is just fantastic. He really is one of the pioneers and true expert in the field of estate planning, and it's just so important. And going hand in hand in that is your business. If you're a small business owner, with regard to being a small business owner, there are many types of business owners that you can be. If you are a sole proprietorship or a single member LLC or a single share corporation, it's just you. You still have to have succession planning because, as Ron pointed out, your business or the value of your business becomes part of your estate. You also have to determine what happens to your business upon your death. Is it going to be sold off? Is it going to continue? Is it a family business, a legacy business from generation to generation? Is that what you want? Do your children want to be part of the business? Understand that in most businesses you've created, and if you are successful enough to be in business to the length of time where you've started it, and now you're either passing on or gifting it to your children, or selling it to your children, depending on how we structure it. There is value in the name of the business. The business name has a dollar amount of value attached to it. The business telephone number has a dollar amount and a value attached to it. The website has a dollar amount and a value attached to it. The goodwill, which is important because a lot of attorneys don't put in goodwill, because it's important to break these things out in your structure, in your deal, in your operating agreement or shareholder agreement, in order for tax benefits and estate planning. So an operating agreement is if you are a limited liability company, and a shareholders agreement if you're a corporation. A lot of people just say, "Oh, I want to be a corporation. I want to be a corporation because I want to be an S corp. I want to be an S corp." You're in New York City. New York City doesn't recognize S corps, so you're going to pay a minimum corporate tax anyway. It's just how the city operates. If you're outside of New York City, then you can factor that into your formation planning. But it's important to realize that when you're forming your company, you have to have, again, either an operating agreement or a shareholders agreement. For the purposes of this discussion, let's just assume you're a corporation. So we have a shareholders agreement. So we have to spell out in the shareholders agreement what you want to happen upon your death. Do you want it sold? Do you want it passed on? Do you want your executor of your estate to take control of it and sell it? You have to direct it. Also, your will should not be in conflict with your shareholders agreement, because then you'll end up in litigation. We've had cases where the will was in direct contradiction to the shareholders agreement, and that gets litigated. I was talking to Ron about a case we had last night where the owner of the company owned 51% of the company, and he gifted that to a charity without the 49% members exercising their right of first refusal, which we'll get to in greater detail. And that was it. Then the charity came in and fired everybody, and they were allowed to do that. We litigated it, and by the time it got to us, it was already a mess. So, but there's not much you can do when you get to us and it's a mess. So you want to get to us early. The litigation factor that we do a lot of litigation, and unfortunately, most of the litigation we do is avoidable if you plan properly. If you sit down with Ron, if you sit down with myself, and go through what you want at the beginning. I tell my clients, you want to build a 100-foot skyscraper. You're the best at what you do in terms of your widgets. You know widgets better than anybody else in the history of widgets. And you're going to build this 100-foot skyscraper. If you don't build the foundation properly, which is your legal planning, and get the proper team together, as Ron mentioned, at around the 3rd floor, your empire will crumble and you'll spend a fortune on lawyers trying to fix it. And it's infinitely avoidable. If you are a multiple business owner, meaning you have more than one shareholder, you have a partner, you have multiple partners, this is where your planning is imperative, because do you want to be partners with your current partner's partner or spouse, however you want to say it? Just as a disclaimer, if I use some gender terms, it's all gender neutral. It's inclusive of everybody, just so that we understand each other. If your partner's husband is not a very nice person and you can't stand the person, he may be your partner if you don't plan for it. So you might want to sit down with your existing partner and discuss what happens upon death. What we do with that is that structure that you set in place is outlined in your, again, for the discussion's purposes, this is a corporation, is in the shareholder agreement. X amount of shares. We talked about the right of first refusal, which means upon death, the existing partner has the right to buy out your shares. Well, wait a minute. How do we do that? Right? We're building $1 million business, a $10 million business. Who's got $5 million laying around? Well, you buy what's called key person insurance. It's a life insurance policy that the business takes out that is payable upon death. So that the individual passes away, the life insurance policy is triggered and buys out their share. That's one possibility. The other possibility is whether or not that you let the estate move forward. Maybe you do want it is a family business and your partners want his children to take over and you don't mind. So then that's fine. You can structure it so that your partner's children or your partner's partner becomes your partner. There's nothing wrong with that if that's what you want. But if that's what you want, you have to plan for it. If you don't want that, then you better plan for it because you're going to have a problem. We have a case right now where we talked about spouses. What about children? We all love our children, but let's be very candid. Sometimes talent skips a generation. Okay. So sometimes we don't necessarily want the child that's born on third base to be our business partner when we've put blood, sweat, and tears into this business for 40 years. And they come along and they pull up in that red Corvette that Ron said they bought and say, hey, partner, I want $250,000 a year because that's what my dad was making. And I'll be here on, maybe every other Thursday just to pick up my check. Uh-oh, what do? You didn't plan for it. And that's absolutely right. He can absolutely do that. You're going to have a problem. You're going to spend a lot of money on lawyers now. So we have a case right now where they built an empire and they have 8 stores and they're doing fantastic. And the older partner wants to retire and he wants his son to take over. And our client hates his son because, like I said, he pulls up in the red Corvette and, hey, I'm here, give me my check. I'm a little oversimplifying it, but that's pretty much the nature of what happened. And so now what are we going to do? And every time he goes to discuss it with the older partner that wants to retire, he says, no, of course my son is going to take over. Why not? You didn't spell it out. So either you reach an agreement or now he has 8 stores. So I suggested we look at the value of each store and you take 4 and you take 4 and call it a day. I try to be practical in my solutions because if you litigate it, the only one that makes money is the lawyers. So I try to be practical. Ron tries to be practical. It's what we do. It's why we work well together, because we take our clients' best interest at heart and try to do the right thing. I run my business like I raised my son. I simply treat people the way I want to be treated. It's the golden rule. It's very simple. It makes life a lot easier, but it's very important that you plan for these things. Now, it's not too late. Don't sit there and panic and say, oh my God, we've been in business for 15 years and I don't have any of these documents in place and I can't stand so-and-so and I don't want him to be my partner. Have the discussion now. We can amend your operating agreement or your shareholders agreement. We can add what's called a buy-sell agreement if you don't want to do the whole thing. But if we're going to do it, we do it right. If you didn't even do it yet, if you don't have a shareholders agreement or an operating agreement, we can still do one. It's not too late. It's too late if one of you dies. Then it's too late. Then it's part of the estate. And give us a call and we'll do the best we can in the litigation. But there's not much you can do at that point. It sort of is what it is, to use the Queen's term, right? It is what it is at that point. This is why planning is so important. This is why you have to have these plans in place. You have to go to somebody that knows what they're doing. You have to go to somebody like Ron or myself, because this is what we do for a living. Don't rely on LegalZoom. You are a unique business. You are a unique individual. You separated yourself in your business from everybody else that makes widgets. Why would you use the same document for $25 or $50 from a downloadable site and say, oh, I'm protected? I don't mind when somebody uses those documents, because very candidly, we make more money off the litigation than we do off the planning. So if you use those documents and I get that, and you come to me and said, my partner has this document and now they're trying to enforce it, no problem. Well, we'll do this, this, and this, and we'll throw that document out, or we should prevail for this reason or that reason. There are very specific things that you need to include in these documents: legal consultations, estate planning. It's not a one size fits all, right? You're not buying off the rack. You want to wear tailored suits. Okay. It's not one size fits all. It's very important. Each industry is different. We're not going to look at the succession planning of a construction business the same as we are as a pharmacy. There are different things that factor into play. There are different considerations that you have. Again, if you want a linear succession, if you want it to be a generational business, a family business, there is not a problem with that. We can do that. It's fine, but we have to do it properly to plan for it. If you have more than one partner, you have to plan for it. Otherwise, now, again, this happens every day. Not everything ends up in court, but do you want to be the one to take a risk? It's essentially a Russian roulette. So you want to make sure that you plan for the worst and hope for the best. You have to plan for everything when everybody's on the same page and everybody loves each other. Because like Ron said, we talk every day, using Ron as an example. If he and I were to merge our firms, right? My firm and his firm, well, I think we're going to go this way. He thinks we're going to go that way. Well, we didn't talk about it and we don't realize it. And when X happens and Ron goes one way and I go the other, then we have a problem because we didn't talk about it. We didn't write it down. And so what do? Well, that's part of your business planning. That's part of the succession planning, right? So what you have to factor in, a perfect example, and I'm a Met fan. So, and if you're not, oh, too bad. I am. So the New York Mets just got sold to Steve Cohen. I don't know how closely you followed that. I tend to read a lot. I tend to be a law nerd, so I look into everything and try to educate myself on whatever I can. That particular sale was estate plan driven. Okay. Fred Wilpon and Saul Katz, who was Fred Wilpon's brother, they own the Mets. They asked their children if they wanted the Mets. Their children said no, except Jeff Wilpon said yes. Well, their children did not want to be partners with Jeff Wilpon. This is the right. The next generation doesn't get along all the time. So they didn't want to be partners with Jeff Wilpon. They looked at it. They said, okay, we're not going to pass the Mets on in estate planning. We're going to sell the Mets and give them their money, with the exception of, and this is my understanding, Jeff Wilpon still owns 5% of the Mets, because instead of getting his money, he got 5% equity. The remaining children got the 5% monetary value. That was all part of estate planning. It's important to have these discussions with your family. Some people think this is taboo and it's a secret. And yes, you don't like to face your own mortality, and I understand that. But if COVID taught us one thing, it's that nothing is certain, and we have to come to expect the unexpected. You expect the unexpected in business, well, that should be planned for, and you plan for rainy days in business. In theory, you should also plan for your end game, your exit strategy. I have clients that specifically plan their business to reach a certain value, a monetary value, and then the business gets sold. We want to reach X amount of value. That's what they do. They build companies, they build up the value, and then they sell it. And that's what they do. And then they start over. At some point, they're going to get tired of that because you run out of steam. We all do. So what do they want to do the next time? Do they want to create generational wealth through that business, through a legacy business? Do they want to stop doing that and just talk to Ron about putting things in trust for Medicaid protection? It's all part of the discussion that we have to have. The reality is that we can structure it pretty much however you want. It's just a matter of what you want to do. So you should talk to your children and say, hey, do you guys have any interest in coming into the business? Or, they work for you now and they hate it. And they say, Mom, Dad, I really don't want to take this over when you're done. Well, that's part of a discussion that you need to have now so that we can plan accordingly so that they don't get it and then squander the asset. And that's not to say that they're going to do something wrong, but if their heart's not into it, it's worth more now than it will be if they've done something or haven't done anything with it and they drive the value of the business to the ground. We have a client right now who is a minority-owned business and showed one owner, only one owner. It's 3 owners, and they showed one owner on paper to be a minority-owned business. You don't have to do that. We can discuss that as well. But you don't have to do that. You're allowed to have more than one owner, and one of them can be a minority and still qualify. There is a way to do that. We can discuss that in greater detail. They did not plan for it. The one owner got sick. We rushed to try to put together an agreement that may or may not have held up in court. We discussed the possibility because he was sick. While we were trying to memorialize and structure what the reality of the corporation was for 40 years, that owner died. What did we do? The estate now owned the business. We had to turn around, back everything out, and talk to the owner's wife and his children, who were the beneficiaries, and go through the whole process again and hope and pray that they wanted the money versus the business. In this particular instance, they got lucky. They wanted the money. They didn't want the business. However, we had to structure a much bigger cash payout because they had all the leverage. So, it will cost you money if you don't plan properly. I've been speaking for 20 minutes. I think that was my time limit. I can keep going. Ron and I can talk all day. But the important thing to remember is this shouldn't be taboo. Okay. You have to discuss this. You have to discuss it with your attorney and discuss it with your spouse and discuss it with your children. Find out what you want to do with your business. You may think that your kids want to take over the business and continue on forever. They may have zero interest in it. A lot of children don't want to do what their parents did. They want to do something different. So let's plan for that so that we can maximize the value of the business and maximize the generational wealth that your business will generate through either the sale or the succession planning. So I'm Rob Mehran from Mehran Law. I don't have a slide. I don't do the slides. I'm going to put my information in the chat, but I can be reached at 516-986-9080, 516-986-9080. Rob Mehran, Mehran Law. Thank you again for listening to us. I think we're going to take questions now. Ron, thank you. Ron and I work very well together. I am of counsel to his firm. I do his firm's or help with his firm's litigation. He is a wealth of knowledge. He's one of the pioneers in this field. If you don't want to listen to me, listen to him. If you don't want to listen to him, listen to me. Listen to somebody.
Well, they should listen to both of us.
They should, but that might be asking too much. Listen to 2 lawyers. I don't know.
Thank you for sharing knowledge, and thank you for this great presentation. And we hope we all learn that how important it is to have discussions with family and business associates, family members and business associates about succeeding plannings and knowing what is going to happen to the business that many of you participants here put the blood to build a building, to build an emporium, and then know what is going to happen next. We are going to share this information. We are going to also share your contact information for future consultations. I don't see any questions on the chat at the moment. There is one. Oh, no, it's closed. It's open. I think they canceled the questions because they learned through the presentation. They got the answer through your presentation. Thank you again, Mr. Fatoullah and Mehran, for being here today on behalf of the Queens Chamber of Commerce Board of Directors, our President and Executive Director, Tom Gretsch. Thank you again, and we are looking forward for more events like this.
Thank you for having us.
Thank you.
Thank you very much. Thank you, everyone.
Thank you, Rob.
Thank you, Ron.